Welcome all. My dear friends, let us continue our journey in the world of patents. Okay, so here you can see the key term here written is opposition. Okay, and in the picture we can see there are very two beautiful roses, but yeah, both are not similar. Okay, so as they are having different properties, different features, opposition can happen. Okay, so here the key term I have taken is opposition. Okay, and a great man has said it is opposition which foretells success. Where there is no opposition, there is no success either. That means opposition is not bad. Opposition is also needed sometimes. Some many more examples can be given that for a democracy, opposition is needed. So many things are there we can say. So literally we can cite various examples on opposition. Okay, so here just take a look what happens. That means this flower is opposing this flower. Okay, just a symbolic picture, nothing else. Why I am telling all these things? Because the form number we are going to discuss today is form number 14. Okay, so till now we have discussed about all the relevant sections and rules based on up to form number 13. That means up to form number 13 we have completed all the relevant rules and sections. Okay, so today is the turn for form number 14, and form number 14 talks about opposition. Okay, that's why I have told you so many things. Okay, so this is the literary world, this is the nature we can say, but we will go to our legal world and see and observe and watch how the term opposition has a very significant value there. Okay, so let us continue. Go to form number 14. The title is Notice of Opposition to Amendment or Restoration or Surrender of Patent or Grant of Compulsory License or Revision of Terms thereof or to a correction of clerical errors. So all these things are included here in form 14. It is a lengthy one. The title is a lengthy one. Okay, and the related sections and rules are also we can say the number is more. Sections related are, the related sections are 57, 61, 63, 78 and 87, and the related rules are 81, 85, 87, 98, 101 and 124. Fine. So here let us briefly describe the related sections. Section 57 says amendment of application and specification or any document related thereto before the controller. Section 61 is procedure for disposal of applications for restoration of lapsed patents. Section 63 is surrender of patents, and the title of section 78 is power of controller to correct clerical errors, etc. Section 87, procedure for dealing with applications under section 84 and 85. Okay, and the related rules we will discuss briefly. Rule 81 says amendment of application specification or any document relating thereto. Rule 85 says opposition to restoration under section 61. Rule 87 is surrender of patents. Rule 98 is notice of opposition under section 87 subsection 2. Rule 101 is procedure to be followed in case of application under section 88 subsection 4. Rule 124 is manner and time of opposition to the making of corrections. So you can see as a whole here there are a number of keywords. One keyword is amendment, one is restoration, one is surrender, grant of compulsory license, revision of terms, correction of clerical errors. So many terms are there, and here you can relate these terms here. Section 57, amendment of application. Rule 81, amendment of application. Okay, and here section 63 is surrender of patents, and here rule 87 is surrender of patents. Fine. So similarly, you can relate all this, particularly the subsections of the sections and the subrules of the rules, with this form number 14. So let us proceed to form number. After refreshing our memory from the old slide about form number 14 and its relevant sections and rules, it automatically comes to our mind that if form number 14 talks about opposition, then also that means earlier we have also read about some more forms which were talking about the term opposition. Yes, it automatically comes. So that's why I have prepared a table here for comparison. Okay, so let us see. Form number 7. The title is Notice of Opposition. Form number 7A. The title is Representation for Opposition to Grant of Patent. And form number 14 says Notice of Opposition to Amendment or Restoration or Surrender of Patent or Grant of Compulsory License or Revision of Terms thereof or to a correction of clerical errors. Okay. So when you compare these three forms, I think it will be crystal clear for you to differentiate between the three, and you will not be confused anymore. Okay friends, that's why I have tried to compare all the three forms here for a clear understanding. Fine. Now let us proceed by picking a rule of the Patents Rules 2003 as amended by Amendment Rules 2021. And here I have taken rule number 101, and this comes from chapter 13, and the title for chapter 13 is Compulsory License and Revocation of Patent. Okay, and here we can see friends, rule number 101 has the title Procedure to be followed in case of applications under section 88 subsection 4. And here from the title itself very well we can see the very close relationship between rule number 101 and section 88. Okay, so by looking at the title only you can realize this. Fine. Okay, so let us go for a detailed explanation. Now we will discuss about the key terms or the key phrases of the respective subrules of rule number 101. Okay, and in total there are 8 subrules for rule number 101. Okay, so let us uh, observe the key terms of the respective subrules. Fine. Okay, so the key term or the key phrase for subrule 1 is copies of the application and of the evidence. The key term for subrule 2 is applicant shall inform the controller. For subrule 3, this is accompanied by evidence. For subrule 4, the key phrase is the date on which such service has been effected. For subrule 5, the key phrase is further evidence or statement. For subrule 6, the key phrase is shall forthwith fix a date and the time. For subrule 7, the key term is the procedure for hearing, and for subrule 8, the key phrase is amend the license granted to the applicant. Okay, so again I would like to say that I have picked up the key terms as per my convenience. You can choose your own. Okay, and try to remember these key terms, and with the help of these key terms you can very well recall the respective sub rules of rule number 101. Okay, let us proceed. So, subrule 1 of rule number 101 says, if the controller allows the application to be proceeded with, he shall direct the applicant to serve copies of the application and of the evidence in support thereof upon the patentee or any other person appearing in the register to be interested in the patent or upon any other person on whom, in his opinion, such copies should be solved. So the whole sub-rule is about solving of the copies. Fine. So here the relevant section number is section 88 and particularly subsection 4, where section 88 is powers of controller in granting compulsory licenses. Okay. So let us analyze the sub-rule. If the controller, see, if the controller allows the application to be proceeded with, that means the controller is now okay with the application and has decided to be proceeded with it. Fine, this is the situation. Okay, now he shall direct the applicant. Then what he will do, he shall direct the applicant to serve copies of the application and of the evidence in support. Application and the supporting evidences. Okay, thereof upon patentee, upon the patentee, that means upon whom? Upon the patentee or any other person interested, okay, interested in the patent, or any other person on whom such copies should be sought as per his opinion. That means as per the controller's opinion. So we can say the patentee or any other person interested appearing in the register. Okay, either or case. Or another or case is that any other person on whom the controller believes that the copies should be sought. Fine. So this way I think the sub rule is analyzed in a very clear manner. So I hope it is pretty much clear now. Fine. So let us proceed for the second sub. Sub-rule number 2 says the applicant shall inform the controller the date on which the service of copies of application and of the evidence on the patent and other persons referred to in sub-rule 1 has been effected. That means here this sub-rule is about informing the controller about the copies of the application and the supporting evidence. Fine. So this is only written here. The applicant shall inform the controller the date. The applicant shall inform the date to the controller. What is the date? The date on which the service of copies of application and of the evidence, that means the supporting evidence on the patentee and other persons referred as in sub-rule 1. Okay, just now we have discussed, has been effected. Okay, so I think this is also clear now. Okay, let us proceed for the sub-rule number 3. Sub-rule 3 says the patentee or any other person on whom copies of the application and of the evidence have been served may give to the controller notice of opposition in Form 14 within 1 month from the date of such service. Such notice shall contain the grounds relied upon by the opponent and shall be accompanied by evidence in support of the opposition. Fine. So the relevant form number here is form number 14, and form number 14 is notice of opposition to amendment or restoration or surrender of patent or grant of compulsory license or revision of terms thereof or to a correction of clerical errors. Fine. So let us analyze the sub-rule. Just take a look here. The patentee or any other person, on whom copies of the application and of the evidence, copies of the application and the supporting evidence have been sought. That means to the patentee and other persons, the copies of the application and the supporting evidence have been given. Okay, now they, that means the patentee or any other person, they may give to the controller a notice of opposition. They may give to the controller a notice of opposition in form number 14 when within 1 month from the date of such service. Fine. Just a minute. Such notice shall contain the grounds relied upon by the opponent and shall be accompanied by evidence in support of the opposition. That means, just a minute, just a second. Now this notice, that means the notice of opposition, shall contain the grounds relied upon by the opponent. Okay, and this shall be supported, or we can say this will be accompanied by evidence, and this evidence will support the opposition. Fine. I hope now it is pretty clear. Okay. And as we know, the relevant form number here is form 14. As we all just I can read it. Notice of opposition to amendment or restoration or surrender of patent or grant of compulsory license or revision of terms thereof or to a correction of clerical errors. Fine. So let us proceed to the next subrule. Subrule 4 says the opponent shall serve copies of the notice of opposition and his evidence on the applicant and inform the controller the date on which such service has been effected. Okay, now you can find out the sequence is followed, right? One after another, stepwise, the incidents or the events are happening. Okay, is in the previous subrule we saw that the opponent filed the notice of opposition. Now what we'll do? Now the opponent shall serve copies of the notice of opposition and his evidence on the applicant, and he or she will inform the controller about what? About the date on which such service has been effected. Fine? Okay. Subrule 5 says no further evidence or statement shall be filed by either party except with special leave of or on requisition by the controller. Okay, now everything is done. Now the case is that no further evidence or statement shall be filed by either party. Either party. That means both the parties. Either or we can say. That means no party is now required to submit further evidence or statement. Fine. Except the exceptional case is that if it is required by the controller, then only they can file it. Otherwise, in normal condition, no further evidence or statements shall be filed by either parties. Okay. Only a special case is that when it is required by the controller. Either we can say with special leave of or on requisition by the controller is the specific situation. Fine. Okay. Now, subrule 6 says on completion of the above proceedings, the controller shall forthwith fix a date and the time for the hearing of the case and shall give the parties not less than 10 days notice of such hearing. Okay. Now, what is the next step after subrule 5? That's why subrule 6 says on completion of the above proceedings, that means up to subrule 6, sorry, that means up to subrule 5. The controller now shall forthwith, now the controller will fix a date, and the time for hearing of the particular case. Okay, and he shall give the parties a notice of such hearing. Okay, and that time period should not be less than 10 days. That means at least a time period of 10 days is given by the controller. Fine. Okay. Now, subrule 7 says the procedure specified in subrules 2 to 5 of rule 62 shall, so far as may be applied to the procedure for hearing under this rule, as they apply to the hearing in opposition proceedings. Okay. That means it is given that for we can say in rule number 62, starting from subrule 2 and ending at subrule 5, the procedures are specified. Okay, and those procedures apply to the procedure for hearing under this rule as they apply to the hearing in normal opposition proceedings, nothing else. Okay, so for this please refer rule 62, and the title for rule 62 is hearing. Okay, and here there is a single star mark. This indicates the words inside the square brackets are substituted by SO 1418E dated 28 December 2004 for of opposition to the grant of patents with effective from 1st January 2005. So earlier this was of opposition to the grant of patents, and now it is in opposition proceedings after the amendment. Fine, just remember this and you can very well recall the whole subrule. Because here the key phrase is the procedure for hearing. When you can remember this particular keyword or the key term, you can very well remember the whole subrule. Fine. Okay. Now, subrule 8. Now this is the last subrule for rule number 101. Okay, so what does it say? If the controller decides to revise the terms and conditions of license, he shall forthwith amend the license granted to the applicant in such manner as he may deem necessary. Okay, that means what is written here? Just take a look. If the controller decides, that means as per the decision of the controller, what he decides? To revise the terms and conditions of the license. That means the controller here decides to revise the terms and conditions of the license. Then he shall forthwith amend the license. Then what he will do? He will amend the license granted to the granted to the applicant in such manner as he may deem necessary. That means whatever he thinks fit as per the situation, in that way he amends the license granted to the applicant. That means he can revise the terms and conditions of the license in the way which he thinks fit, or which he thinks is the necessary for the specific situation or condition. Fine. So this way friends, all the sub rules of rule number 101 are completed. Please go through each and every slide. Please go through the direct. Okay. If you have any questions, please put them down in the comment box. Okay. Keep learning, keep enjoying. Okay. Fine. The reference is Patents Act 1970 as amended by Amendment Act 2005 and the Patents Rules 2003 as amended by Amendment Rules 2021. Okay friends, thank you all for watching my video and listening to me. Okay, so please like, share and subscribe the channel, and please put down your compliments, comments and queries in the comment box. Thank you. God bless you. Stay safe, stay blessed. Jai Hind.